Good afternoon, everybody. I am mandated to give you a balanced and non-biased view of copyright, which makes me feel like I'm on Fox News. But I do have my biases as a copyright lawyer. I hope they won't interfere too much. Now, what I'm attempting to do today is to, on one hand, give you some basic concepts of what copyright law is, what it protects, how to preserve it. These are very fundamental notions. If any of you were in the morning session, we touched on a few of them at that time. I'm also going to talk about licensing as a general process in publishing, and I'm going to introduce you to a word that includes licensing, but other things as well, and I'll be talking about those, and that word is clearance. Now, what I've handed out today is what I call a content clearance handbook. It is organized as a critical path tool that answers what I consider to be the fundamental question that you should be asking yourself as publishers, and if you are authors, you should be asking it as authors. The question is, how did I get the right to publish what I am publishing? And this question can be applied to anything that's in, on, or around the book that you are publishing. All of those things, which I'm calling in my handout content, to use kind of a broad, neutral term, all content may be owned and controlled subject to copyright or other intellectual property laws like trademark, publicity rights, trade secret rights. They may be owned and controlled by somebody else. Now, there are reasons why you can use them without permission, but there are some uses that will fall outside those concepts, and if they do, you are at risk of committing an act of infringement if you use the content without permission. So the thrust of the hour we're going to spend together is to understand how you identify these clearance issues and how you resolve them. Now, the reason this ties into licensing is that licensing is a term that lawyers use to describe the legal relationship between somebody who gives permission to somebody else to use an item of intellectual property. Fundamentally, if you are a publisher and you acquire a manuscript from an author, you need that author's permission to publish. And that permission may take the form, should take the form, of a full-featured author publishing contract signed by both parties. That's a form of clearance too. That's a form of permission too. But there are other things that may be less obvious to you. On the online edition of the New York Times today, there was a pop-up ad that said, in giant letters, John Hamm, and then in smaller letters said, did not write this book. But he wrote, and it goes on and says, but he wrote the foreword, and it was an advertisement for a book. Now, the question, and by the way, the name John Hamm was displayed in precisely the way the opening titles on Mad Men are displayed. The first word in red, the second word in black, block sans serif letters. So they were playing on two things there. They were playing on John Hamm's name, which is protected not under copyright, but under a body of law called right of publicity. And they were playing on what lawyers call the trade dress of Mad Men. The look and feel of the titling on Mad Men is a form of trademark called trade dress. Now, the reason I bring it up is, I hope and I suspect that somebody said, how do we have the right to use John Hamm's name to promote this book? How do we have the right to use the trade dress of the Mad Men opening titles to promote this book? And the answers would have been either the right is not needed because it's not a protected use, or the right is not needed because it's in fair use, or the right is not protected because it's in the public domain. Those are all potential answers. But none of those would apply to this particular example. The final answer to the question is, we got the right because we asked for and received permission. Now, as a lawyer, I'm going to tell you, permission is only as good as your ability to prove that you got it. Ideally, it would be something in writing that says what it needs to say and is signed by the person who needs to sign it. So later you can say, how did I get permission? Here's my permission contract. Sometimes it's done more casually in exchange of emails. It can be done obliquely. But unless something is done to show that you have provably obtained permission, then you're at risk of a lawsuit. Now, I'm going to give you an example of a clearance problem that came up in my practice that I think is a classic illustration of what I'm talking about. A very famous current American politician, whose name I will not mention for sake of client confidentiality, was walking through a crowded room after a speaking event. And my client held up a book that she had published with a very distinctive and quirky title. And as this politician passed her, she held up the book cover. And the politician, in passing, said, "That's great," because there's kind of a joke in the title. "That's great." On her next printing, on the front cover, she put a blurb that says, "Great!" exclamation point, and then the name of this politician. And she had asked me, "Can I do this?" And I said, "I don't think you should do it because that invokes the right of publicity, which is the use of the name, image, or likeness of some other person to promote or endorse your product. You need the permission of that person, and you didn't get it." And the client argued, "Well, she said it in public, it's not a lie." I said it would be prudent to ask for permission. She didn't ask for permission. Now, I really thought that this would just fly under the radar and nobody would notice and nobody would care until she got a demand letter from the law firm saying you need to shred all the books in existence that have this claim of endorsement, and you have to reprint without it. That's one of the consequences of not clearing what you need to clear. And it is the best example I can give you of how this goes beyond that fundamental question of, do I have the right to publish the author's book? Which you could answer by saying, yes, I have the author's signature on a contract. But you should ask it about the blurbs, you should ask it about the cover art, the interior art, photographs, indexes, extensive quotes from an interview with a third party, anything that's in, on, or around that book that's subject to the laws, not only of copyright, but of trademark, right of publicity, trade secret, need to have an answer. Now, and the permission you get is a form of licensing. The technical legal term is licensing. Now, I want to come in a little more in more detail on the concept of situations where you don't need permission. If something is in the public domain, well and truly in the public domain, then by definition it belongs to the public and everybody may use it however they wish. So for example, anyone, this is a case I happen to work on, anyone may today write a Sherlock Holmes story. Sherlock Holmes is in the public domain. You can make a Sherlock Holmes movie, a Sherlock Holmes TV show. There's nobody you need to ask for permission because the Sherlock Holmes character and the Sherlock Holmes books and stories are all in the public domain. And that may turn out to be true of a lot of the things that you use as content in your publishing. Another thing that doesn't require permission is material that was never under copyright. For example, copyright does not protect book titles. Copyright does not protect facts and figures. Copyright does not protect ideas, theories, approaches, techniques. What does it protect? It protects works of authorship in a fixed medium of expression, but not the facts or ideas that are contained in that. Anyone here could write a new Sherlock Holmes story, but the only copyright you would get in that Sherlock Holmes story is what is new and original that you created, and anyone else may copy what is in your story that came out of the public domain in the first place or was never protected by copyright. Sometimes authors will come to me and say, I did a book and I did a lot of research for my book, a lot of historical research, and here's a novel that came in and took a lot of the details of my research and put them in a novel, and I want to sue, and sue for copyright infringement. And under that scenario, no copyright protected content has been infringed, just facts and figures. So you don't need permission to do that. Sometimes it's a close call, and it can be very treacherous to make that decision unassisted by some expert advice, at least that's my opinion. For example, pure statistics, just numbers, facts about events of history or what the effects of a drug are on the body or death rates or actuarial tables, things like that. That raw data is not protected and you don't need permission to use it. But if somebody has gone to the trouble, I use the word tables, I'm going to take that out of the example of what could be used, actuarial tables. What you can't use is the specific selection and arrangement and coordination of data that has been organized in a display for the reader, like a chart, a graph, a table. Those are potentially copyright protectable. Those do need permission. There is a safe harbor of fair use for content that is copyright protectable. You don't conclude that you don't need permission because it isn't protected by copyright or that it's in the public domain. You conclude that it is under copyright, but you're allowed to use it under the so-called fair use doctrine. Fair use says that you may make limited use of the content of a copyrighted work for specific approved purposes as long as you meet the statutory tests of fair use, and that will be a defense to a copyright infringement action. So one of the things you may decide is the thing you want to publish, the content you want to publish, does include quotations copied from another work, but you don't need permission because it falls under fair use. And every book that's published to one degree or another has some content that is arguably used under fair use. Fair use is kind of the lubricant of the publishing industry. If everything was protected, nothing new could be published. I write a lot of books on the subject of history. There are quotations on every single page of my books. They're short quotations. They're credited to the source. They're used for approved purposes of fair use, and nobody has ever complained about it. But that's an example of when it is fair use. There are examples when it isn't. There is a big problem in asserting the right of fair use, because fair use is not an affirmative right. It is a defense. You don't find out if you were right or wrong about asserting fair use until you've been sued and gone to court and had your case decided. That's when fair use is determined. You know, when I was getting ready for today's session, I was looking back at the Google book case and the big settlement that was in negotiation for so many years, and the case kind of just dried up and blew away. That entire case, which was such a sensation, such a revolutionary case for so many years, was nothing more and nothing less than a case about fair use. What can you do and what can't you do under the fair use doctrine? And it generated a lawsuit that lasted 6-7 years and cost tens of millions of dollars in legal fees. At the end, it was decided what Google was doing was fair use. So the fair use can be a successful legal strategy. But when I have clients come to me in advance of publication and say, is this or isn't this fair use? All I can say is we can make an informed guess, but it will only be a guess. And you have to be able to accept the risk that you would turn out to be wrong. And you have to accept the risk that even if you're right, you may be forced to go to court to prove it. So it's not anything that you can rely on in any substantial way. There's always some risk to fair use. Now, many publishers, as I've said, are willing to take that risk, and I have at least a couple of publishers who I work with regularly who are very tolerant of risk, and they play right up to the line, And what we do together, what I do as their lawyer, is to design how far can we go before we fall over that line from fair use into infringement. Now, even if you have gotten permission, which, by the way, is one of my takeaways, one of the mantras that I repeat to my clients is, if you have zero tolerance of risk, if you don't want to go to court to vindicate your fair use rights and spend hundreds of thousands of dollars doing it and risk losing, if you don't want to ever go there, cut it or get permission to use it. That's simple legal advice. If you've got content and it belongs to somebody else in some way and you want to use it, but you don't want to take a risk, ask for permission, and if you don't get permission, take it out. That's the clear way to go. However, even if you ask for permission, you may not be completely safe unless you are also very vigilant and mindful in the uses you make of the material you're permitted to use. And I'm going to I used this example this morning, I'm going to use it again. I had a client who published a travel book and went to a commercial photographer and bought a package of beautiful color pictures of the destinations that were in the travel book and got permission to use them, permission in writing to use them. And the permission, as I think I've hinted already, doesn't necessarily take the form of a lawyer-drafted contract. In this case, it was an invoice. The photographer sent an invoice and described what rights were being granted and what it would cost. And the publisher paid the invoice and marked paid and stuck it in a file. And the book was selling well. So they went through several printings, and then they revised it, went through several printings of the revised edition, and they went to a third edition and several printings of the third edition. And then they got a lawsuit served on them by a process server for willful copyright infringement. And the client called me up in a great state of indignation. I cleared the rights to these photographs. I have an invoice. I paid the invoice. I said, what does the invoice say? Invoice said $1,500 for one printing. $1,500 for one printing. Did he get permission? Yes. But he exceeded the scope of his permission. So The client calculated what would have been owed at $1,500 per printing for all the printings of all the editions. And I made a settlement offer and said, we're willing to, make good on this. It was an oversight, not intentional. Here's what we're willing to pay. And the lawyer on the other side said, that's what you pay when you ask for permission. When you don't ask for permission, you're an infringer, and we're asking for $150,000 per work infringed. Now, it didn't end up at that huge number, but it certainly ended up at a number well above what the licensing fees would have been. And the problem happened because of an absolutely unremarkable and perhaps even inevitable practice of the publishing industry, which is when you have it on your checklist, clear the rights to the photographs, you check it off and you forget about it. That's it. Nobody is commonly going back to the contract file every time they turn on the press or every time they revise. There's a penalty for doing that. The penalty is you might pass from being a permitted user of a work under copyright to being an infringer. And that's a big divide. Breach of contract is different than copyright infringement, and the penalties are much steeper and graver. Now, I've made the point already, and I want to highlight it, that in this handout, I'm inviting you for each item of content to run through a list of questions, critical path questions, which will either move you on to the next question or take you aside if you have further clearance issues. And I want to emphasize that this is not just copyright clearance issues. This will also include the trademark issues that would arise, for instance, in the John Hamm ad, or the right of publicity issues that arise in the John Hamm ad, and also in the ad, in the book blurb for the author who caught the politician's eye. I come so close to mentioning that politician's name every time. Okay, now, that's in section 2. In section 3, I have given you an overview of copyright, the shape and scope of copyright, and because that's in the course description, I'm going to hit some of those high points now, so that you will, as promised, come away with at least some fundamental grasp of the scope of copyright. The first thing to bear in mind, I can't remember if I've said it in this session already, but I said it this morning, is that copyright no longer requires any formalities whatsoever to come into existence. Copyright exists when a work of authorship is fixed in a medium, tangible medium of expression. What that means is that if I stand on the street corner and give a speech to the crowd, no copyright exists. If I sit down at my word processor and write my speech, copyright exists, and it exists the minute I finish typing. I don't have to put any notices on it, I don't have to register it, I don't have to renew it, I don't have to do anything. The copyright exists, and I own it 100%. There was a time in the not too distant past when that wasn't true, and some of that old law is still, kind of in the air. It used to be that if you published a work of authorship without a copyright notice, it was injected into the public domain. It's not such an old and antique notion. I have a client who paid a lot of money for motion picture rights to a novel, which we are now discovering may have been published without notice during the period when that was fatal to copyright, which would have meant she didn't have to pay for the movie rights because, as I've told you, if it's in the public domain, it belongs to everybody. But that's not the law anymore. It has not been the law since 1978. It used to be that you had to renew copyright after the initial term of 28 years. That hasn't been the law since 1978 either. When copyright comes into existence, it remains in existence for one continuous term, and when the term is over, it goes into the public domain. No renewal is required. No registration is required. There are good reasons to do all of those things, and I'm going to encourage you and specify why in the next few minutes. But if you ask me, as I was asked this morning, is there a copyright if I haven't registered it? Yes, there is a copyright. How long does it last? It lasts for the life of the author, or the life of the last surviving author, if it's a co-authored work, plus an additional 70 years. That applies to most works. There are exceptions to that rule if it's a work for hire, in which case the protection is 95 years from publication or 120 years from publication, whichever is longer. That's if it's work for hire, which means that it's not the work of a human being, it's deemed to be the work of someone else, the commissioning party who hired the person who actually created the work. I'm going to keep on the life plus 70 track because most books, most works of authorship in publishing are subject to that rule. And it remains in effect without any formalities at all. The author, who starts out as the owner of 100% of the rights under copyright, may dispose of those rights to anyone he wants or she wants for any amount of money that he or she is willing to accept. And those transfers of rights should be and can be embodied in contracts. They could be the author-publisher contract. They could be an image license for illustrations to be published in a book. They could be the cover design. They could be the appendix, the foreword, the preface, whatever item of content that's subject to copyright protection owned by an author can be transferred in one way or another to the publisher. There are three ways to do that. One way is by assignment of rights, which conveys ownership of those rights from the author to the publisher. This is like buying a house. The house was owned by one owner. It's assigned to the new owner. Now the new owner owns it. The old owner doesn't. The new owner can do what they want with it. You can also convey rights under copyright by license. License conveys only the right to use the work of authorship, not ownership of the work of authorship. And I compare this to renting that house instead of buying it. You can live in it, but you can't paint it, you can't add on to it, you can't tear it down, you can't sell it to somebody else. That's what a copyright license looks like. Now there is a third way of transferring ownership, which is the work for hire route, which creates a legal fiction. If you hire me to create a work of authorship and it's properly characterized as work for hire, you are the author, not me. Now, and I've already said, the kinds of permissions you get in the clearance process are often just licenses. If I, by the way, even in the case of something like a blurb, if I write you a letter and say, here's what as I'm sometimes asked to do, here's a blurb you can use on your book. That's a license. I'm giving permission to use the blurb. For whatever rights there are in the blurb, I still own them. There is a rule under copyright. It's previewed to you in the course description. It's a statutory right for termination of transfer. Transfer means a license, an assignment, any form of permission that I may give as the owner of copyright to someone else. The statute says that I have the absolute, unwaivable right to terminate that transfer, to terminate that contract, to terminate that permission. and I can't be made to waive that in a contract. If the contract says you waive your right of transfer under the Copyright Act, that clause is not enforceable. What that means is that even though publishers commonly ask authors to sign contracts that say this contract, the term of this contract shall be the term of copyright in the work as it may be extended, renewed, or restored, as long as there's copyright. The reality is it's not that long because the author can terminate that transfer. Now, the termination right doesn't arise until 30 years after the contract is signed, and there's a window of 5 years, and then it closes. So if the author doesn't exercise the termination right, it goes away. And in fact, because of the long period of time before the right even opens, it may not be of consequence to the publisher. They may not care. Or the author may not be aware that they have that termination right. But that's kind of the life cycle of any form of permission or any transfer of rights under copyright. There is a trapdoor under that transfer. The one exception to that is work for hire. An assignment can be terminated, a license can be terminated, work for hire cannot be terminated. Can you think of why? If you've really grasped this crazy lawyerly concept, you'll understand why. Who is the author of the work under work for hire? The commissioning or hiring body. So the termination of transfer right belongs to that person, not to the person who actually sat down and did the work. That's why work for hire defeats the termination right, because it creates the legal fiction that the hiring or commissioning person is the actual author. Yes?
I've got a question. Would you ever, so if someone files a copyright, let's say 2006, and then they revise it, would they file another copyright?
This is an interesting question. Let's talk about this is registration. This is a registration question. As I said, you're not, strictly speaking, filing a copyright. You're registering a copyright. Copyright exists. And you're going to ask the Copyright Office to register it in the official records of the United States. By the way, you can do that at any time after the work is created, whether it's published or unpublished. If you register within 90 days after publication, you get some very, very powerful remedies as the copyright owner. You're entitled to statutory damages without proof of loss. That's where that $150,000 per work infringed comes from. Now, statutory damages are in a range from $200 to $150,000, and the court decides where you fall in that range. But you don't have to come into court with any proof that you lost income or that the defendant achieved profits at your expense. So it greatly simplifies your rights. You also get the right, if the work has been registered within 90 days after publication, you get the right to your attorney's fees. And very often, the sheer cost of hiring a lawyer to go to court is prohibitive and means you don't really have a remedy. So that's one good reason to register and to register promptly. Once you have registered, the work is protected in the form in which it is registered, and in fact, the Copyright Office will not allow you to re-register it in a different form. For example, if you registered the print edition and now you're trying to register the ebook edition, they won't accept it. It's already registered. When can you re-register? You can re-register when the work has been revised in some way that is entitled to separate copyright protection. And I'll give you an example. If I write a book and register that book, and then I issue a new version that has 3 new chapters and a foreword, I can re-register that edition, but the new copyright registration will cover only the 3 new chapters and the foreword. The other parts of the book are still protected by the earlier registration. Now, let's say, as this has happened more than once in my practice, a client says, we registered this work and now we've really cleaned it up. We corrected typos and spelling errors and grammatical errors, and it's a much tighter book now. We want to register the new edition. Can't be done, because those little fixes don't rise to the dignity of copyright protection.
How would you know then if something's really been registered with the Copyright Office?
Well, this is a very fundamental question. Works published after 1978 should be in the public database that's available at the Copyright Office website. So and that's searchable by title and author. So you can tell, and by the way, this can be a key question, I'll tell you why. You can go to the website, you can search on your own initiative and find out whether a book has been registered since 78. However, books published prior to 78 may still be under copyright and still represent a clearance issue. The rule of thumb is, if a book, or any work, not just a book, a song, a poem, a movie, anything, if it was published in the United States in or after 1923, it may still be in copyright. If it's published before 1923, it's in the public domain. The works published between 1923 and 1978 are not in the online database. So you have to do a much more expensive form of searching to find them. And works published between 23 and 78 were under the requirement for renewal. So if they were registered but not renewed, they'd be in the public domain.
Okay.
Yes?
I'm under the impression that you have 1 year to register copyright.
No, that is erroneous.
No. So what
You
is,
can register at any time.
oh, so there's no limitation on
No. Let me be clear on this. There's no obligation to register ever, and there's no time limit on when you can register. And it is very, very common for books to be published, not registered, an infringement is detected, you want to go to court and sue for infringement, then you register. Now, that's not ideal, because under that picture, you're not going to get your statutory damages. The registration has to be, I'm giving you a lot of detail now, but if the registration is within 90 days after publication, you're entitled to your statutory remedies, attorney's fees and statutory damages. If it is registered prior to the commencement of the infringement, you are entitled to statutory remedies. However, if you see the infringement, run down and register for the first time, you don't get them. Now, by the way, the Copyright Office has an expedited registration service that I think it costs $700 just for people who want to get to court. You know, they want to file their lawsuit. They want to get this thing registered. It can take 6 months to a year to register by the slow boat method. So if you pay the business class fare, you can get registered faster. But I want to dispel this notion. There's no limit, and you can register at any time.
What is the global protection of a U.S. copyright?
We belong to several international copyright treaties or conventions, the most important of which is the Berne Convention. And what the Berne Convention says is, we will protect in the United States the rights of Berne Convention authors to the same extent that we protect US authors. And so every country that's a signatory to the Berne Convention, which is most countries in the world, it's a long, long list. If you go to that country, you're entitled to sue, but you have to follow the laws of that country, and you'll get the remedies that that country offers to its own citizens. The United States courts cannot hear a case for an infringement in Yugoslavia. You'll still have to, well, there is no more Yugoslavia, so nobody can hear that. Slovakia, but you can go to Slovakia and sue. That's the international reach of copyright. There has been an interesting case. I mean, this is a fine detail, but it's a very interesting case. for many, many years, this principle that US copyright law did not extend beyond the borders of the United States meant that if you licensed an edition, a cheap edition of your book in Asia, nobody could buy the book at the reduced price, ship it back to the United States, and sell it at a discounted price in competition with your editions. That would be considered infringement. The question was, what about the first sale doctrine, which says first sale doctrine says once a book is sold, it can be resold freely without any restrictions placed on it by the publisher. Well, the courts had said the first sale doctrine doesn't apply to sales outside the United States. In a recent case, they reversed that. And they said, even though the first sale doctrine is a doctrine of US copyright law, we're going to enforce it in Asia so that in this particular case, I think I'm blocking on the name of the publisher, big publisher. Even though they had licensed the edition I think it was in Thailand, it was a very expensive medical textbook. When it came, I think it's Wiley, if I'm not mistaken. Once it was published in Asia under your authority, the first sale doctrine kicks in, and that means it can be resold freely without restrictions, so that when they brought it back to the United States, they were no longer treated as infringers. So these things can take some odd bounces. Is there any, yes, go ahead.
So you said before that you can't register an ebook of the same title after the fact. So does that mean that if a book appears as an audiobook, an ebook, or...
Audiobook, you can do it. Ebook, you can't do it. Because, well, let me, I don't mean to step on your question, but let me answer it in two ways. Yeah. The ebook consists of what? The text of the book in a screen-readable format. What's the difference between that and the printed book in terms of content? Zero. So that's why they won't accept it. What is an audiobook? It's a vocal performance. It may have sound effects. The recording itself is a different medium of expression. That can be registered. You can have a separate copyright for the audio version, but you can't have a separate copyright for the ebook edition.
The ebook is still covered under...
Still covered under copyright. But you'd be infringing, it's a very technical point, but the work that's being infringed in a pirated ebook is the registered print edition. This is really such a narrow technical issue that it shouldn't be of too much concern for me. You can sue.
John,
Yes.
and just for sake of fun and a point made well,
Mhm.
I took the risk to take a picture of an intellectual property attorney presenting and tweeted about him on
Great.
the date of you. So what does that constitute in terms of copyright?
You have asked a very interesting question. One of the most common questions or issues that comes up in my practice, I do what's called vetting, which is to read a book in advance of publication to see if it has legal risks associated with it. And very often, if it's a family history or a memoir, there are going to be family photographs. The question I have to raise is, because it's consistent with the question that I told you about right at the beginning, how do I get the right to publish these snapshots? Well, the common answer is, well, they're in my scrapbook. They belong to me. They're my photographs. The answer, as lawyers see it, is no. The photograph is a work of authorship. It is subject to copyright. The copyright, in most cases, belongs to the photographer. So your picture of me is your copyright and not my copyright. Now, as a practical matter, and this is relevant to the question, how did I get the right? You might very well not be able to find, you may not know who took the snap in the family album. Who knows? Even if you know, how do you find him? Maybe he's dead. Who are his heirs? I mean, you could take this thing to an absurd extreme. And very often, since it's always a matter of risk tolerance, very often a publisher will say, well, look, this is a family photograph, it's from a family album, the author's album. We're not going to sweat this too much. But sometimes, not often, but sometimes somebody pops up out of the woodwork and says, that's my snapshot. Where did you get the permission to use it? Now, let's stay on your subject. What do I own in a picture you take of me? I don't own the copyright, because that's your right. I do own my name, image, and likeness rights. And that right is defined by the use you make of the photograph. What I would argue is if you're tweeting it, that's kind of a reportorial function. You're saying this is what's going on at Publishing University, and that's why you put it up on Twitter. If you used it as a product endorsement, if you used it for packaging or merchandising, if you made a bobblehead of me, then you would need my permission. Yes? I'll come up to you.
It's just interesting what you're saying because I saw Carrie Fisher speak once and she was talking about after Star Wars that there was all these products of her. Were they exempt because it was part of the movie?
No. They were doubly protected. If you had very interesting question. By the way, we saw the same show. We saw that show. If you made a Princess Leia bobblehead, you arguably need Carrie Fisher's name, image, and likeness rights, and you need the studio's character rights.
Signed off on all that stuff then.
Either it's here's what I'm going to say. Either it's infringing or somebody signed off, and I would say two people had to sign off. Now, this becomes even more complex because when Carrie Fisher signs a contract to star in Star Wars, she gives up some of those right of publicity rights to the studio, and the studio controls the merchandise. This is true of Major League ball players as well. The individual football players and basketball players don't control their right of publicity, the leagues do. And so if someone wants to make a bobblehead of a famous player, they go to the league, they don't go to the individual. And that's probably true of Carrie Fisher too. But if she didn't sign away those rights, then in fact, her permission would have been needed, the studio's permission would have been needed under copyright. And if they hadn't gotten both those permissions, it would have been an infringing product and it could have been sued over. Now, some infringements are not sued over, for example, very commonly because it's of a politician and they don't want to seem like a jerk, or because it seems like too small a matter, or it's never even detected. That happens too. Yes?
Kind of following, like, my question may pertain to this with, if you had an image or illustration that you had the assigned copyright to for your book, but then you want to make figure or stuffed animal out of that image, does that copyright carry over? You need to get separate permissions?
This is a very astute question. I'm glad you asked it. To answer that question, I need to familiarize you with one concept about copyright, which will suggest the answer. A work of authorship is protected by copyright in its entirety, and that copyright covers a literally unlimited range of uses. For example, you write a book. Let's use that as an example. You write a book, it's a novel. It's 300 pages long. One of the rights under copyright is to set that into type and print copies of it as a book between covers and sell it. Those are the book rights under copyright. You could make a movie out of that book. Write a script using the characters in the plot, put the actors on a stage, film them, and release it as a movie. That's the movie rights under copyright. To do that, you need the authority of the author. It's one of the rights that he or she owns. And there is no limit to that list. What we always say, and I said it this morning, is copyright is not one thing, it's many things. It can be conceived of as a bundle of sticks. Each stick is a right. Book rights, movie rights, TV rights. And each stick can be subdivided into other rights. So you have hardcover book rights, trade paperback book rights, mass market paperback book rights, ebook rights, audio book rights. You have Spanish language rights, Croatian language rights. You have the right to sell an English language book in Spain, Spanish language book in the United States. All of those are rights under copyright. So anything you want to do, this is part of this clearance checklist. You ask yourself, how do I get the right to do what it is I'm doing? So, for example, you may not have what are called commercial and merchandising rights, which would be the right to take characters from your novel and make a doll, or a lunchbox, or a t-shirt, or a bobblehead. And these rights can be very exotic, and they can change. The examples I used this morning, which are very good examples, nowadays, in contracts, one commonly sees not only book rights and ebook rights and movie rights and all these other kind of rights, commercial rights. I've seen contracts with amusement park ride rights, the right to make an amusement park ride out of the book characters. I've seen grand opera rights, and I told the story of the cover image. This gets right to your point. The very, very famous, iconic cover image that accompanied a book called Midnight in the Garden of Good and Evil, which was a photograph of a statue at a gravesite. The photograph of that statue was owned by the photographer. It was cleared, permission was given to use it as the front cover of the book, and it became an iconic cover. I saw it used on a tin of cookies. So in a bookstore, but in the cafe of a bookstore, were cookie tins. That's not grand opera rights or amusement park rights, those are cookie rights. Who would have thought that there were cookie rights? Well, there are. That was a right under the analysis that we're making that starts out with the photographer. If the publisher only got cover rights for the book, they can't do the tin. They have to go back to the photographer.
So if it's broadly assigned though, do all those fall under it, or they need to be specific?
It's all in the language of the permission. This is why a formal permission document, whether it's a book contract or a license or something, whatever it is, a photo license or an art license, it needs to be clear enough that you know you have the rights that you need. I'll give you an example. A few years ago, many years ago, I had a client who was a graphic designer, and she called me from the floor of BEA. And she said, she was hysterical, I have an infringement suit. What's your infringement suit? I license an image to a publisher for a book cover, and I'm walking around the floor and people are wearing t-shirts with my book cover on it. Now, the question is, when a publisher acquires the rights to use an image as a book cover, do they also have the right to use it in advertisements of that book cover, in the catalog? Can they make little promotional t-shirts to wear on the floor of BEA? They weren't selling t-shirts, they weren't in the t-shirt business. They were promoting the book. And that's a very interesting question. It would have been better for the publisher if the description of what the permitted use was on the book cover and in advertising, publicity, and promotional uses of the book cover, including merchandising uses. You know, this is the challenge to the lawyer to draft a language that's comprehensive enough and also flexible enough that it covers the intended uses. Yes?
Do publishers need a new right to offer books through subscription services like Oyster?
This is such an interesting question. The question is whether publishers need a new and additional right to sell books through a subscription download service, which is kind of the latest flavor of the month. And it has already surfaced in my practice. If you have a contract that says any medium now known or hereafter devised, I think you're safe. If you have a contract that allows sale, it includes ebooks, and it allows sales through all channels of trade, I think you're all right. Because after all, a subscription, ebook subscription, the product is the ebook. The subscription is really just a pricing model. It's not a new medium at all. So I think under either of those two angles of attack, you do not need additional rights from the author. However, there's a big if here, which is if there is a royalty clause that provides for compensation. And the question is, that ebook revenue on the subscription model is going to be divided by the number of books that are available and the number of downloads per book, and you're going to be doing some complicated math, and you're going to be coming up with some pretty tiny numbers per book. And
You know what they've been using? What formula they've been using?
well, the clients that I'm counseling are using the ebook royalty, but they're applying the percentage to the net revenue attributable to that book in the subscription model. And I think that's highly defensible. I don't think this is a big problem. There are very big problems for contracts that did not include ebooks at all, and now the publisher wants to do ebooks. On those kinds of questions, I send them back for contract amendments. I say, let's get the authors to sign up, and if they don't sign up, then don't do an ebook. That's the, those are the breaks. But the subscription model, do you all know what a subscription model is? Okay. On the subscription model, I think most contracts are going to have enough in them, if you have ebook rights, to get by. But everything, as I say, the devil is always in the details. It depends on what the particular contract says. It's not something I can generalize about. Okay, we're almost out of time. I'll take a couple more questions we have. Good.
I am an independent editor, freelance editor.
Yeah.
And there's always that little bit of worry, it's like how much of, if an author says, yeah, this is my work, or I've got the permissions, I've done this, is there any liability on me if I don't
You're doing editing on a contract basis for the author,
for the author, sometimes for publishers?
and you're not introducing content.
No. Well, I mean, like any kind of revisions or anything like that, but I'm not introducing.
But you wouldn't say, oh, let's make this guy a tax cheat, or let's make this guy a child. Well, that's the principle.
Right.
By the way, we're now in a different area, not copyright, not trademark, not intellectual property. We're in the area of defamation and invasion of privacy. This is covered in my clearance handbook. The risks that we're looking for include these risks of libel and invasion of privacy. I'm just going to answer this question. I would say, as a general proposition, you are not at plausible risk for infringement, invasion of privacy, defamation, if you are not adding content. However, having said that, it is not unusual for agents to ask for representations, warranties, and indemnities, and it would not be untoward for you as a practitioner to say, if there's anything in the content you provide me that exposes me to legal risk, you will indemnify me against that risk. The one caution, which is practical, not legal, is that you have to maintain a good record of what you put in, like through a redlining process or something like that. So that, because the contracts I draft for the authors who hire private editors actually include representations, warranties, and indemnities that go in the other direction and say you, the editor, will not introduce into the manuscript any content that will expose me to legal risk. So it could be reciprocal. Yes?
My question is, if I wanted to take part of this and reproduce it on my blog, and do I have to I obviously have to credit you, but would I also need to get written permission?
Oh, you're asking me a tough question. Because I'm a softie, you can reproduce it on your blog as long as you credit me. And I'm giving you permission, and it's actually, it's on this tape. I'm giving you permission to that. As long as my name is there as the source. You have my permission. So that wouldn't be fair use anymore. That would be a permitted use or licensed use.
And you need to buy the tape.
Well, I don't get any money from the sales of the tape. Yes?
Going back to work for hire,
Mhm.
When is that established, or arguably established? Do both parties have to agree in writing that that's the type of?
There are some very strict rules, and I want to give them to you. Work for hire arises under one of two circumstances. One circumstance does not require a contract, the other does. If someone who is an employee of another person creates a work of authorship within the course and scope of employment, that work is automatically work for hire with no writing required. Now, I want to give you a caveat. I have a number of clients that are publishers. They have aspiring young journalists sitting at the secretarial desk. Their job is to answer the phones and write letters. They want to write articles for the magazine. They are not work for hire because it's not within the course and scope of their employment. However, if you hire someone and their job description is to write house copy or captions or edit or whatever it is, take photographs, create drawings, that's their job description, it's work for hire. By the way, I have another client who is basically a media company, but she has lots and lots of people who have non-media jobs. But our employee handbook says the job description of every employee of this company includes the creation of intellectual property content for use in our products and services and is thus work for hire. So she's trying to say everybody's job description includes it. Now, that's for employees. And you have to be able to prove they were actually employees. They were paid as employees. There was deductions taken from their withholding and co-payment of taxes and workers' comp and all that stuff. If you can't show that, then they're not going to be automatically work for hire. The other category of work for hire is the independent contractor category. To get work for hire status for an independent contractor, there must be a signed written agreement. It must say that it is work for hire. It must be signed before the work is substantially completed. It cannot be retroactive. And it has to fall into one of several statutory categories that are eligible for treatment as work for hire when an independent contractor is involved. Some of them are publishing related. A translation can be a work for hire. An index can be a work for hire. Questions and answers for a test can be work for hire. Contribution to a collective work, like a chapter in an anthology. You know, there's a book of 30 chapters, each written by a different contributor. That can be work for hire. The writer of a foreword to a work by another author. That's a collective work. That can be work for hire. What can't be work for hire is a book written from beginning to end by one person. So you can't get a novel as work for hire unless you go to the freakish extent of hiring the person and putting them on the payroll. Okay?
And signed by, you said written agreement, signed by both?
Both parties, yeah. Well, look, I think that it would probably be enforceable if it was signed by the party who's doing the work, but it would be a different document. It would be an instrument of transfer, not a contract. A contract is always a bilateral thing, and there's just no question it's better if it's signed by both. Okay, I think I'm running out of time. I'll take one more question.
I am assisting a retired professional baseball player who's writing his memoirs. We've got a contract, and in our contract, he is responsible for securing rights and permissions for quotes, pictures,
Mhm.
and whatever from any professional baseball players or league people.
Mm-hmm.
And his answer to me was, "Oh, don't worry, we're only talking about my friends." Should I encourage him to get something?
Oh, absolutely. I wouldn't just encourage him, I would tell him it's legally required. Yeah. I want to tell you absolutely the ugliest cases I've ever been involved with throughout my entire career have been between friends and relatives. Those are the worst, the absolute worst. And let me also say, I think I mentioned this, I can't remember which session I mentioned it in. Professional ball players may not have the right to give the permission. They may have ceded that right to their players' organization. So the fact that a player says, oh, you can use my name, image, and likeness, may mean meaningless because it may be the team or the league that has to, or the Players Association that has to give the permission. Okay, I'll tell you what, I'm going to formally close, but I'll stay here for questions if you'd like. Thank you all. Thank you.